Hey everyone, thanks for tuning in. Today I'll be discussing in this presentation relevant federal healthcare regulations for digital health, early stage digital health firms. As the healthcare industry grows, especially with its use of technology and the adoption of technology, early stage firms are popping up that are solely focused on the use of what we call digital health. So it's important to get to familiarize yourselves with um, existing federal regulations as well as those that are becoming legislation right now that are being drafted by the legislator. And if they have become legislation, when they're going to become regulations, and then that's when we have to really take note of them and take that into consideration when starting and or running a digital health firm. So, what is health information? This definition of health information comes from the HIPAA regulation. So, this is just an overarching definition of what the law constitutes as health information. And I'll show you later in this presentation that um, this just health information alone is not what's covered under HIPAA. There's more specific details that have to be checked off. So health information is any information, including so genetic data as well, that's recorded in any form or medium. So that means it could be written on paper or typed into an electronic health record. It's created, so it has to be created by a healthcare provider, meaning um, the health information is obtained, say, when you go to a physician and they take your vital signs and then they record that. That's health information. Um, it's also could be created by a health plan. And health plans, if you think about health insurance companies, like health information is important because it's used for billing. And then there's the list is kind of exhaustive here. You can see that there's life insurance, employers, health care clearinghouses as well. And the second part of the second prong of this, which constitutes health information, is that it relates, and this is most important, it relates to the past, present, or future physical or mental health condition of an individual, um, or the provision of healthcare to that individual, and or the past, present, or future payment for the provision of healthcare to an individual. So any of those three subparts in that second section would constitute health information. So say you already satisfy the first part in part two. If you satisfy at least one of those three um, categories, then the information of question would be health information. So now, because the theme here is digital health, I'm going to introduce you to the general definition, legal definition of electronic media. So we can see how that we incorporate electronic media with health information to get our digital health um, data, which are more specifically defined in the statutes that I'll later present here in this presentation. So electronic media in general is electronic storage material, so say something that's stored on your hard drive electronically, and so this is important. It could be in a hard drive, it exists and sit in a hard drive, but it could also be transportable, meaning one, you could just pick up your laptop that with the hard drive in it and the information stored in it and move it, or you could, if it's a desktop computer or any type of computer, you put a flash drive or an external hard disk in there and you store the media in that disk and you take it out and remove it. That's also transportable as well. So it covers anything, any type of digital media that could be stored and then also, also transported. It doesn't have to be transported, but this is just to cover and make sure that, like, hey, like if they didn't include this provision, then people, you would have a loophole in there saying like, oh, I, had this electronic media on my, computer, but I moved it to another one. So this law doesn't apply to me anymore. So that's not the case. This transportable and removable provision plugs that loophole. Transmission media, so we're talking about the actual transmitting of this media, is used to exchange information that is already in storage. So this is basically kind of reiterating what I discussed previously. So this is the actual act of transmitting. So sending, you could also send information that's stored on one device to another device. So instead of physically moving a hard drive, send it electronically, like via an encrypted email. So in the subsection, you can see transmission can occur over the internet, private networks. So when we say private network, we would be a good example would be like a hospital network where they have their electronic health record system, and it's a closed private network. It's not open to the public. And then it also, states in there storage devices that contain that electronic media. One important thing to note is that if the information being exchanged did not exist in electronic form immediately before transmission, it's not considered to be transmissions via electronic media. So what that means is that if you had a notepad with some notes on it, so your notes, that's information. That's not electronic. That's not an electronic form. Something that's written on paper clearly is an electronic. But so if it's in that form immediately before the transmission, it can't be considered transmission via electronic media. Meaning you can't like take that notepad, type it up, into an email and then send it. The media has to have originated in electronic form. You can't just convert it and then send it electronically if it was originally, say, a paper or non-electronic form. So now we're getting into the HIPAA privacy and security rules. These rules are enforced by U.S. Department of Health and Human Services, the Office of Civil Rights. So that's a sub-agency within HHS. So first we'll discuss the entities that are covered or that are regulated under HIPAA, both privacy and security rules. If you're regulated under HIPAA, it's both the privacy and security rules that you must adhere to. So first we have covered entities. These are the more obvious ones that you would likely interact with when you're, having healthcare interactions. So first we see there healthcare providers, doctors, clinicians, dentists, etc. And then two is health plans, so your health insurance companies, HMOs, health maintenance organizations, and there's also government programs that pay for healthcare. So that would be examples would be like Medicare, Medicaid, or the VA. Because those are healthcare, they're pretty much their healthcare payment programs. And then the third, this one is not as common, you don't see as much, healthcare clearinghouses. These are entities that process non-standard health information that they receive from another entity, and they put it into into a certain standard. So for example, standard electronic format or data content. So what they would be doing is taking raw data and standardizing it. So like raw health data and putting it in a standardized form, essentially. Another important note at the bottom, healthcare providers. So this is important. Healthcare providers are only regulated under HIPAA, are only HIPAA regulated covered entities if they transmit any information in electronic form in connection with a transaction for healthcare services or treatment. So that is the hook right there. It has to be services rendered, and then there has to be transmission of information, which is payment information, electronically in return for those services. So in these days, that everyone falls under that, unless you go to some, if you're in a rural area and there's one town physician that doesn't have an extensive computer network, and you pay cash for a healthcare service after you receive it there, that actually that physician would not be a covered entity. But because everything is digitized these days, especially payment processing, third-party payers, insurance, use of credit cards, everyone's going to be a covered entity in terms of healthcare providers. They'll be covered entities under HIPAA. And next is the business associate. So this, when we get into this, it might seem a little tricky if you're not too familiar with business associates. You've probably heard of them before, but when it gets down to the details and determining what's a business associate and like what the relationship is, it gets a little tricky. So I'll try to clarify that for you. A business associate is an entity that performs certain functions or activities on behalf of the covered entity, the CE, which involves the disclosure or use of PHI. So throughout the discussion of HIPAA, over and over again, you're going to see use or disclosure of PHI. That's important because that's the crux of the privacy rule. Use and disclosure of protected health information is what's actually being protected here. And when you go to a physician and you sign a HIPAA consent form, that consent is the overall nature of the consent is that you're granting your healthcare provider consent to use and disclose PHI for providing you healthcare. So these next two bullet points kind of show different ways in which the business associate relationship can work. Or just to back up a bit, what a business associate you could kind of would it be analogous to would be a subcontractor. So first you can see that a covered entity can be the business associate of another covered entity. So, and I'll explain that after I show you the second example. Also, a business associate can be the business associate of another business associate. So this could kind of start to sound kind of, crazy in your mind right here. But if you really break it down, you'll see that it's pretty straightforward. And when you're entering into these relationships, you're not really thinking about this complex, this way of saying this word salad of saying BAs and CEs or CEs of BAs or whatever. So the relationship depends. So this is the test right here. The relationship depends on which entity receives and uses the PHI, thus enabling that entity to perform specific functions or services for the other entity where the PHI originated. So for example, let's talk about the first bullet point where a CE, a covered entity, can be the business associate of another covered entity. So say we have a situation where it is an orthopedic practice. And the covered entity would be that orthopedic, so I'll say ortho practice A. That would be the covered entity. They're a little short on radiologists to interpret very complex MRIs and scans. So they need to get subcontract out, essentially, radiologists to review those imaging studies. So they contract out a radiologist from radiology group B to come and interpret a certain set of X-ray images and imaging studies that were produced by orthopedic group A. So that radiology group itself alone is already a covered entity. But now, because the orthopedic group, which is the covered entity in this relationship and in general is subcontracting out a service that requires them to disclose protected health information, which are those imaging studies, to another entity, that makes that the other entity, which is the radiology group, the business associate. And I'll show you on the next page. So when you have a business associate relationship, you can't just share all, the covered entity can't just share all the PHI that it has with the business associate. It only can share the minimum necessary amount of PHI that's required in order for the business associate to fulfill and perform its tasks, which the CE is contracting it to do. So here, this is where the business associate agreement comes into play, and this is required under HIPAA, under the HIPAA privacy rule, and it also in the statutory guidance, in the regulatory guidance, OCR provides template business associate agreements. So you can start with a boilerplate agreement, but for each relationship, when I say relationship, I mean business associate relationship with like between two BAs or a CE and a BA. You have to carve out. So with these agreements, you have to carve out what the amount, specify which PHI the covered entity is sharing with the business associate, what functions and services or tasks the business associate is performing when it uses that PHI it's receiving from the covered entity. And there also has to be stipulated in that business associate agreement a termination event, whether it's a date or an event. So that means, so for example, you could either say the covered entity is sharing this such and such amount of PHI with the business associate until the term date of January 20th, 2023. So you could make a specific date in there. Or it could be an event that triggers the termination. Once the business associate completes task A, task B, task C with the PHI that it was given by the CE, that would terminate the business associate contract in that relationship. So now that we see here that business associates are receiving PHI, so that means that what we have in the red here, business associates are held to the same level of liability under HIPAA as our covered entities. So if you're, say you're a finance firm, say a medical practice who provides healthcare services, which is a covered entity. It's a small one, but they need help with billing and financing. So they need to contract out a firm to take care of billing and finance matters. That would be a business associate, and that would involve sharing PHI to the extent that they will be seeing diagnostic codes and billing codes, which indicate the type of health issues that people have in their medical records who are the patients of that covered entity. So business associates, same liability. They will face the same penalties for violations of HIPAA privacy and security rules. So protected health information. This is the data that is regulated under HIPAA. So this is more specific than just health information in general, which is what I first started discussing in this presentation. So protected health information, PHI, is what we refer to it as, is health information that is individually identifiable. So protected health information, how you approach this and how you look at this is that if you say you have a medical record sitting in front of you of somebody you don't know, and any piece of individually identifiable information on that medical record, say a paper record, has been blacked out. It's been redacted, like birthday, social security number, phone number, address, date of birth, and any piece of information, which is what we call individually identifiable information, that would enable someone to figure out whose medical record that is. That's what we refer to as individually identifiable information. So that's a component that has to be with protected health information, and that's why it's protected, because it's stored together with information that can identify the patient. So it includes health information. So we're starting with the definition that we discussed in the beginning of the presentation. So health information that is transmitted or maintained in electronic media. So that's where the electronic media comes into play here. And sometimes we see that referred to as EPHI. Um, People vary on whether or not they use it. PHI could be referring to both. Sometimes, if you want to be more specific, as we were discussing, people might use that, and it's just in writing. And these days, because it's required under law that medical records be in digital form, electronic form. We're pretty much only dealing with EPHI. So if you see PHI written somewhere, it's likely referring to electronic EPHI. And then the second part is it is transmitted and maintained in any form, in any other form or media. So that means that's basically saying that it's can be transmitted in any other form as well as electronic form. So before electronic health records came into play, we had paper health records. That was still PHI, it just wasn't EPHI. However, what's excluded from the definition of protected health information from PHI is health information that pertains to records that are covered by FERPA, which is what we refer to as the educational equivalent of HIPAA. It's the federal privacy law for higher education academic institutions. So say this does come up as an issue sometimes and is kind of administratively litigated. I've seen this come up in OCR before, where if you are a college student and you go to student health services, that can be considered a health record, but not HIPAA protected PHI, because it could be part of maybe it would be stored as part of your academic right or in your academic file. So that's one of those weird kind of like gray areas there, where even though the student health has physicians and NPs and PAs who are collecting vitals and performing treatment, that information is being stored as part of your education record. Also excluded are employment records held by a covered entity in its role as an employer. So say the covered entity, the employer is a hospital, and it has employment records electronically on its employees. That would not be PHI. Last, if a person is deceased for over 50 years, um, their medical records or anything that would have been considered PHI for them is no longer considered PHI. There's a term limit to how long, if you've been deceased for 50 years, I don't think you'll be too worried about someone seeing your protected health information. So uh, for PHI, I briefly touched upon this earlier. Um, PHI, for use and disclosure, individuals have to grant consent to use for covered entities to use and disclose their PHI. So again, that's like when you go to a physician's office and you sign that HIPAA consent form. It's for them to use and disclose your PHI for carrying out treatment. So you actually see right here. Um, so you're giving them consent to use and disclose their PHI for things that other than what I lined out here. I should back up a bit. So you sign your HIPAA consent, and it's a thick packet. It lays out everything that you're consenting to. And then here, the important part is once CEs gather protected, or you could say, protected health information on a patient, they are exempt from the consent requirement to use and disclose that PHI that they have if it is used to carry out you want at least one of three different purposes. So it's covered entities. So say a hospital does not need a patient's consent to use or disclose its PHI on that patient if it's for the primary purpose is to carry out a patient's treatment. So the hospital A could call hospital B and say, here, I'm going to send you this individual's health record, their PHI. Um, I'm having trouble coming up with a diagnosis. I need a fresh set of eyes on this. That is for treatment purposes. That hospital A does not have to go to the patient and ask for them to get consent to disclose their PHI to another healthcare practitioner for the specific purpose of providing them treatment. Also, carrying out billing. Um, the hospital does not need to receive the patient's consent to send their PHI, and this would be really the billing codes that also constitutes PHI. They don't need to get consent to send it over to billing in order to carry out billing and payment um, processes. That would be overly burdensome. And then the third part is kind of a catch-all. It's if the PHI is used to conduct healthcare operations. So any type of practice that is not just ancillary, but that is essential for the overall provision of healthcare services. Um, if it's directly related to that, and this is kind of where BAs come into play. Um, Ancillary though, not directly because BAs need an agreement, but those types of scenarios is where healthcare operations would come into play. So first, there's the HIPAA privacy rule. So the HIPAA privacy rule, it's what it addresses is the confidentiality of an individual or patient's PHI. So it's just focused on the confidentiality aspect. So this is accomplished through regulations that are designed and intended to prevent unauthorized parties from being able to identify a particular individual to which that particular set of PHI belongs. So essentially, it's what the privacy rule seeks to do is to prevent outside other unauthorized parties from being able to um, associate health information with the individual it belongs to. That's because you could have redacted medical records that don't contain any more, where all the individually identifiable information has been redacted. You could see that someone else could see that, and it won't violate the privacy rule because you don't know whose health information it belongs to. The big one here, and this is where the hefty CMPs, which are civil monetary penalties, come into play, and where the most action takes place, is the security rule. So this addresses the maintenance, transmission, and storage of PHI, and specifically ePHI, because it's all pertaining to electronic storage and transmission of protected health information. And the security rules regulations, they set forth a series of minimum standards which CEs and BAs must adhere to when storing, maintaining, and transmitting PHI. So, for example, a minimum standard would be a hospital has to uh, have all of its employees change their passwords into their network every 3 months. Certain administratively seemingly tasks like that pertain to the electronic protection of PHI. So naturally, security rule enforcement is OCR's highest priority, and violations are penalized with CMPs, which are civil monetary penalties. And the reason for this is that security rule violations have the potential to cause substantially more harm than privacy rule violations. Uh, for example, because if you fail to satisfy the security rule regulations on how to protect and secure your EHR and your hospital network, and as a result, there's a data breach where patients' PHI is disclosed and exposed to malicious actors, that would cause much more harm than if privacy rule violation occurred, in which, say, you're in the waiting room of a doctor's office, and the nurse comes out and calls you in by your full name. That technically would violate the privacy rule, because it's showing everyone else in the waiting room that, hey, you're at this doctor's office receiving, especially if it's a specialist, receiving this treatment. That does not reach the level of harm as health records being exposed and released to the public. And also, you can see like the number of victims affected is greater, and the sensitivity of the compromised data. So violations occur when CEs and BAs fail to implement those security rule regulations, which we refer to as safeguards, or if they do, they fail to maintain compliance. So that could be requiring testing, running tests to test the security and integrity of your network. This happens with, like, for example, I get emails from Jefferson's IT all the time that there's going to be Epic, which is their EMR downtime, which they run updates, and they do fake attacks on the network to test its integrity. So the violations occur regardless of whether. So you could violate the security rule, of course, by failing to implement a safeguard, regardless of whether any unauthorized PHI was disclosed as a result. However, and we'll see this in the next slide, OCR penalizes violations that result in unauthorized disclosure of PHI by imposing enhanced CMP. So if you violate the security rule by failing to meet the minimum safeguard standards, you'll likely receive, if it's your first time, maybe some type of warning or technical assistance, but you'll receive a CMP. But if that negligence, that failure to comply with the security rule regulations, you were out of compliance, and while you were out of compliance, there was an unauthorized disclosure of PHI, for example, due to a data breach, you're going to receive much higher fines in the form of CMPs from OCR. And the factors that affect the severity of the CMPs are number of victims affected, level of harm occurred, the CE's intent or the BA's intent. So was it on purpose, or were they just negligent? So on purpose, when I say on purpose, that means like, hey, they wanted to, cut costs and cut corners. So we didn't want to, spend this much money on this type of software that would, help satisfy the minimum standards for protecting our computer network. So that would be more of a purposeful thing. Negligent would be more so that it wasn't really, they didn't really intend to. Maybe their IT staff they were short on the IT staff, and it just slipped their mind. Also, the last two were kind of reflect mitigating factors. So good faith actors that CEs engage in to mitigate the resulting harm. So if they immediately notice that there's a data breach and they were out of compliance, they immediately notify all the victims, and they provide them with, say, like 2-3 years of free identity theft monitoring, and notify OCR right away. That would be an example of a good faith effort. And also, when the covered entity proactively engages with OCR and cooperates with their guidance and directives in order to come back into compliance. So these mitigating factors would usually occur more so when the violation was a result of of negligence on behalf of the CE. It wasn't their intention to violate the security rule regulation. So here's an example scenario. A hospital covered entity has a data breach of its EMR system and compromises the PHI of all its patients. The hospital was not in full compliance with the security rule standards when the breach occurred. So here, the hospital is still liable for enhanced CMPs for violating a security rule, regardless of whether the security rule violation contributed to the breach. for example, by increasing its network's vulnerability. So this exemplifies, how you're still liable under security rule for violations that occur. So to be more specific, say the security rule violation had to do with that they were violating. It was the only security rule violation that they were out of compliance with, or only security rule standard they were non-compliant with was a requirement to update passwords every 3 months. But they had a data breach that had nothing to do with that. This was a highly sophisticated data breach that had nothing to do with somebody just logging on using another person's password. The existence of a violation, a security rule violation that is ongoing while say a data breach, unauthorized disclosure occurs, that increases, that would result in enhanced CMPs, but not as much. Like a mitigating factor would be that the specific rule that they violated wasn't at all related to the data breach. The data breach meaning the unauthorized disclosure of PHI.